Are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Good morning. Court Radio is now in session. Call 215-227-2727. When you've got legal questions, we've got the answers. This is Court Radio. And now here's your host, Dean Weitzman.
Good morning and welcome back. It's Court Radio. I'm Dean Weitzman and it is Sunday, September 18th, 2016. This year has flown by. Folks, we've got a special guest in the studio, fresh from his 3-month vacation down the shore. It's the one, the only, Saul Langsam.
And a very good morning to everybody.
Hi, Saul. Welcome back to Court Radio.
Why, thank you, Dean. I missed you.
It's good to be missed. Well, you'll hear Saul today. We're going to talk about some wills and estates issues and some deeds and whatnot. And you can call with any legal issue you have. I'm sure either Saul or I will be able to tackle it at 215-227-2727. Funny thing is, that's the Court Radio number on Sunday mornings, and it's the My Philly Lawyer number for the rest of the week. All you got to do is pick up the phone and give us a call at 215-227-2727. Remember, one legal question at a time. No subparts, no double questions. You'll get canned and thrown off the show. But if you do ask one legal question, and it's a good one, I might give you a T-shirt today. We got our new Court Radio T-shirts in stock, all the way up to a 2X. So if you're bigger than 2X, go on a diet and give me a call back. 215-227-2727. Okay, let's talk about the news for a second. There's a bunch of stuff happening. There was a bomb blast in Manhattan yesterday. There was a bomb blast in New Jersey yesterday at the start of a marathon for the Marines. They're not sure if there's any connection between the two, and they're not sure if it's related to any terrorist activity or just some wacko. So stay tuned, I guess, for further details on those stories. There was the Pennsylvania High Court's retirement age was pushed from 70 to 75. Excellent. Excellent. Yes, I think most folks still have a working brain between 70 and 75. What do you think, Saul?
Put me on the spot there.
Getting close, aren't you?
Getting dangerously close.
Mandatory retirement at My Philly Lawyer. Cart them out. No, really. I think that's a good thing. You know, a lot of our judiciary are forced to retire at the age of 70. And they still have so much to give, and they still want to participate so much in the process. And unfortunately, the law was the law, and they were done at 70, whether they were capable of engaging in their passion or not.
We see it in our own office. We have several people that are of that vintage.
Yeah.
And they contribute nicely.
Yes, absolutely. Let's see here. What else is going on? There was a crazy rampage in West Philly over the weekend where two people, the killer and an innocent victim, lost their lives, and many people were injured, including police officers. He started with a police officer, a sergeant who was in her car, was shot multiple times. And it just, the studio's falling apart. It just goes to show you, what I've been saying all along, and that is that mental health is the biggest problem our country has to face. Stop trying to put people in jail. Save all that money for people who really are not violent offenders, okay? Save that money and put it into mental health. We walk around the streets of Philadelphia, and you walk over and around people who are insane every day, who can't care for themselves, and yet we ignore them. And it makes no sense. And then we have these incidents where somebody insane gets a hold of a weapon and the end result is never good. Mental health needs to become priority for our country's money. Really, that's how do you determine what a priority is in your country? It's how you spend your money. We spend our money on prisons, fools, and we don't spend it on hospitals. It just makes no sense to me. I don't know. I mean, again, I don't want to run the world, but if I did, it would be a better run world. It would. 215-227-2727. Philly City Council starts to play with medical marijuana. Derek Green held some hearings last week, and we're starting to gear up. It's coming. The state has enacted the laws. They're kind of wrestling with how to enact them, but they will be enacted. And medical marijuana is going to come to Pennsylvania. So the city of Philadelphia needs to start thinking about zoning and where we're going to have these dispensaries and what they're going to look like. And if you want to participate in this, give Derek Green a call down at City Council. He's kind of spearheading it for the city. 215-227-2727. So, Saul, that's the end of the news. Let's talk for something. I got a call or an email over the weekend from somebody whose mom put a property in the name of mom and a daughter, one sibling, but there are multiple siblings. Now, I don't know what happened from a family standpoint, but they all want to be on the deed now. And it poses a problem. Once you give, donate, or gift your property to a child, that child is the owner of the property. How do you get them off?
Well, that's correct. It's not a legal problem. It's more a moral problem within the family if there's disappointment among siblings. Once the child's name appears on the deed, only the child can actively sign off on that deed to transfer the property to anybody else, including back to the parent.
Right. That's right. Once you gift your property, you make a decision to gift your property to your daughter. Your daughter at that point is the owner of one half of that property. That's what you've given her. And she has absolutely there's nothing you can do, you as the person who gifted it, there is nothing you can do to get that property back. It's hers. And it's hers to keep as she sees fit, or she can give it back to you, or she can give it to her siblings, but it's her choice. And there's nothing a court's going to do to intervene in that situation. It becomes a family issue, as Saul says.
There's a valid reason for adding the name of a child or the name of children to deeds. It's a good estate planning tool.
Why?
Which ultimately will reduce the inheritance tax that the survivors will be obligated to pay to the Commonwealth of Pennsylvania.
Okay, so we have an inheritance tax. It seems like it's less and less applicable. When I started practicing law, pretty much everybody had to pay a death tax. Now, spouses don't, right?
That is correct. There's no inheritance tax between spouses.
Okay. But there are for children. What is it for children? Do you know?
For children, we just had a family that came to us and property ended up being distributed to a child and also to a friend of the decedent, because there were two parcels of real estate. And the inheritance tax associated with the transfer to the child was only 4.5%. Whereas the inheritance tax on the property transfer to the friend of the decedent was 15%, so it was substantially more.
Okay, so it depends on your relationship to the person who died. That tells you how much tax you have to pay. If you're a child of the person who died, your tax is 4.5%. But if you transfer your property before you die, then there's no tax?
That is correct. If you transfer the property, there's no inheritance tax. However, there could be a transfer tax if the real estate is in Philadelphia, which can be 4% of the market value, depending on what your relationship is to the person who owns the property.
Well, what if you're a child?
If you're a child, you fall into an exempt category, and there is no transfer tax.
Okay, so if you're a child of a decedent, somebody, your mom and dad are getting old, and and you want to try to save 4% or 4.5%, you can transfer that property into your name now. You're tax exempt on the transfer tax, and you save on the inheritance tax of 4.5%. So for every $100,000 of property, you're saving $4,500. It's not insignificant.
Right. That is the tax. The inheritance tax obligation is limited to $4,500. Whereas if you're not a child,
a friend.
If you're a friend, it's 15%, and the category in between is for siblings, brothers and sisters, which is 12%.
Okay. 215-227-2727. Transferring property should be done with the advice of an attorney and carefully, because as I started this conversation with Saul, there's a family out there who transferred a property to one sibling. Maybe they thought, she would take care of everybody else, blah, blah, blah. But it may not happen that way. Or they may decide, hey, we want to put it in everybody's name now. And if that sibling says, no, I'm not doing it, you're done. Okay? You're done. That's it. Forget it. It's not happening. Let's talk to Joe from Downingtown. Joe.
Hello.
Hey, Joe. Welcome to Court Radio.
Hey, how are you doing this morning?
We're doing well, thanks. You live in Downingtown?
Yes, indeed. I have a question for you.
Wait, I got a question for you. Do you need a passport to get to Downingtown?
Yeah, right.
I've driven past Downingtown. It's a long ways from the city.
No, it's not. It's on a train ride. It's about 30 minutes. It's one of the fastest growing communities around. But let me say this to you. I'm dealing with a tricky attorney. I had a friend that had an accident, right? The guy, it's in New Jersey, hitting him back. Clearly, the other party fought. Now, my question is simple. How many years do we have through the insurance company?
You have 2 years from the date of the accident, exactly 2 years from the date of the accident, unless the person who was struck, the injured party, is a minor. Then the statute is tolled until the minor turns 18, and then 2 more years. So it could be a longer statute only in the case of a minor. But if you're an adult, 2 years from the date you were struck.
Well, let me say this. He clearly told me, because we're still in the insurance company, that I have 4 to 6 years, which I knew was a lie.
Well. Hold on. Let me clarify, because if let's say you got hit by somebody who doesn't have insurance. Okay, if you get hit by somebody who doesn't have insurance and you have something called uninsured motorist coverage on your policy at home, and you want to collect from your insurance company, you have 4 years from the date of the accident, because that's a contract. A contract in a contract in New Jersey and Pennsylvania is a 4-year statute. It is not the same as a claim under the tort laws, which is 2 years. If you sue the person who was at fault, that's 2 years. If you sue your insurance company under your uninsured or underinsured motorist, you have 4 years.
He had about $5,000 insured, and the attorney threatened me, and I went up to the $5,000. He wouldn't represent me. He had $4,000 worth of insurance, so that would be underinsured motors. It gets tricky.
That's right. If you're struck by somebody who has a minimum policy, let's say a $15,000 policy, and your claim is worth more, and you have underinsured motorists, you can turn back to your own carrier to compensate you for the differential between the value of your claim and the amount of coverage that the tortfeasor or wrongdoer had.
Thank you, sir. You cleared a big cloud.
All right. Thanks so much from Downingtown, Joe. Have a great Sunday, and thanks for listening to Court Radio.
All right. You do a great job.
Thank you. I think I do. But it's only because of people like Saul who actually come in here and keep me straight. All right, let's talk about wills and estates for a second, Saul. We're kind of touched upon it with the transfer of properties pre-death. what other things can people do before they actually pass to prepare for that day?
Well, there's estate planning, which is a vast area, and within the estate planning area, there are, depending on the assets that you own and the extent of your family members and your relationship with those members, you can do a multitude of things. Least of which, and we didn't talk about that before, if you are charitable minded, the law certainly encourages people to leave to charities, and they make it very attractive because in most instances there's no tax consequences in leaving property to various charitable institutions.
Okay. So you can give some of your property to charity or all of it, and that's a tax-free transfer. And you may get a benefit, I guess. Well, it depends on how you transfer, whether you do transfer it pre-death in some sort of a trust or post-death, and you just, give it away after you pass. But you can transfer some ownership interest before you die, which may give you a tax benefit while you're living.
The charitable institutions make it very attractive today. If you're willing to leave part of your estate to them, there are various programs, earnings programs, which will allow you to realize some type of financial money stream while you're still alive.
Right. Okay. So there you go. There's certainly a lot to do. Now, when we get to talking about wills, how complicated is it to create a will to transfer your property to your loved ones?
It's not complicated at all. It's a process that our firm has been doing for many, many years, and it just requires a conversation with our client. Either they come to us with plans already thought out or written out, or we'll ask them a series of questions. They will provide us with information, and based on that information, we'll put something together for them.
Can this be done over the phone in a consultation with you?
In many instances, we've actually done that as a courtesy to our clients. If they can provide me with the information that I need, I can make it extremely easy. They need only to visit us one time, and the completed document will be waiting for them. The advantage of coming to our office is, under Pennsylvania law, the will requires 2 witnesses, and both the witness signatures and the maker of the will signature needs to be notarized. And we have our notaries on staff in our office, so our clients will walk out of our office with a fully executed document.
Wow. And what's the cost for a simple will to transfer property from yourself to loved ones on your passing?
I think we've been very reasonable, and we have not even increased our fee over the years. A simple will document will cost our clients $250.
All right, there you go, folks. That's all you got to do. Give Saul a call at the office, 215-227-2727, any day of the week, and he'll talk to you over the phone, get your information, have the documents prepared. You come down to the office for about 15 minutes. You have the documents notarized, and you leave with wills in hand. I know people are hesitant to. People don't like to think about dying.
Well, I'll tell you. Clearly, there has been a noticeable change. If you take a look at the generations, for example, our parents' generation subscribed to this concern about signing a document and not being here shortly thereafter. And I will say this, for our millennial generation and even the Gen Xs, they're much more sophisticated in that regard because they put a value on estate planning. And they will tell you that even if they have $100 in the bank, they want to reduce to writing who is to receive it because it takes the guesswork out of it completely.
I agree, but I definitely believe there's a group of people who don't like to think about it. What happens if these folks don't actually call you and they don't create a document and they pass?
Well, if you are the owner of property, whether it's real estate, whether it's investments, whether it's collectibles, antiques, In the absence of a will document, the Commonwealth of Pennsylvania has a statute, an intestate statute, which dictates who the next people are to receive property, and it's all based on the degree of the relationship to the decedent. And this creates a problem in many instances because, for example, if a spouse passes away, if a woman passes away and she's survived by a husband and children, then the intestate statute talks about so much money going to the surviving husband, and then the balance of the estate is divided among the husband and the children. But if there is no husband, then it'll go to children. If there are no children, it goes to parents. If there are no parents, it goes to brothers and sisters, and that creates a problem in more instances than not.
And that problem, folks, is multiplied when we have blended families. So if, as Saul describes, you have a husband, but he's not the father of the children, and you have children from another marriage, and you want to send all of your property to your husband, and you don't want to send any to your children, but you don't make a will, it will all go to the blended family. It'll go to your children and your husband when you pass.
That's correct. We had a client just the other week who came into the office. She was a single woman, and she was talking to us about the need for a will, and she came in with the notion that she did not need a will. So I began to ask questions of her. She was not married, and she had no children, which is significant. So under the intestate statute, her only heirs would be her sister and two brothers. She had no relationship with her two brothers, and I explained to her that if she did not leave a will, her estate would go equally to her sister and to each of her brothers. So a brother would receive a third, the other brother a third, and the sister a third. And she looked at me with her eyes wide open and said, I do not want my brothers to receive anything from my estate. And I said, that's why you need a will. And we prepared a will for her, which left everything to her sister.
Boom, problem solved really quickly, really inexpensively, and you can tuck that document away, and it's good forever.
Good forever.
Yeah, I mean, so it really makes all the sense in the world to do this. Let's talk to Patrice from Alany on line 1, Eric. Good morning, Patrice.
Yes, good morning.
How are you this morning?
Great, yourself?
Say again?
My dad passed in 2007. It was 4 of us. He had multiple properties, and his will was very direct. 2 of us was head of the estate. They were taken off from orphans court. Everybody got all their properties, and after they was taken off, it was put into another lawyer's hands. And he sat on it for years, and now it's back in my hands. And my inheritance tax is like about $6,000. My dad had all these taxes that were due that nobody took care of, and my home is not even in my name yet. And am I responsible for all these debts by myself? Is anybody else held accountable for it?
Well, you got to give us a little more information. Is this debt that you claim, these taxes, is this for a property that you are now the owner of, or is it for the entire estate and all of his property?
Well, no, not all of his properties, just the one that was willed to me. The inheritance tax that I didn't know how much was due or how to do anything is now about $6,000, and his federal taxes were not done. And I just heard that they're over like $50,000 now.
Okay, well,
that's due.
Yeah, and so the answer probably is that while, for instance, on the federal taxes, that's an estate debt, so it's going to be potentially against all estate property.
But let me just interrupt. Federal estate taxes applied to estates that are in excess of $5 million.
Maybe it's federal income taxes. Income taxes.
Right, his federal income taxes, right.
Yeah. So the income taxes, are going to be assessed against his estate, and as such, they would be able to attach any property that was owned by the estate. Now, what happens, Saul, when a property is transferred? Okay, you prepare a deed after the death, and a property is transferred to the beneficiary of that property. But there is a debt out there that could attach to that property before it was transferred.
Let's use a simple example. Let's say that the decedent had a $10,000 credit card bill, and he owed American Express $10,000. And the decedent owns a multitude of properties. The obligation is not a personal obligation of any of the beneficiaries. The obligation is the obligation of your father and his estate, so that the representative of the estate, the executor, or if there's more than one executor, they somehow have to be creative. And I'll give you an example. They have to be creative, and they have to find a way to generate that money so they can pay the bill. Now, I'll give you a simple example to help you illustrate this. Parents passed away, and they owned a home, and the home was left to their two children. Right. The estate had no money. The house was worth $1 million. The inheritance tax to the two children is 4.5% of $1 million, and they came to us wondering, what do? We don't have any money. So the solution that I suggested to them that they followed was I transferred the ownership of the property into both of their names, and then I assisted them in acquiring a home equity loan, which paid for the taxes. And they were perfectly content with that, and the obligation was paid. But if you don't have the luxury of generating that money, you have to find a way, meaning the beneficiaries of that estate have to find a way to come up with the money to pay the tax bill, because the tax bill is not going away. And if you transfer the property out of the estate that owes taxes, the tax collector, if they are aggressive, they can come after the property that's been transferred into your name.
So transferring a property into your name isn't going to solve the problem. But you had started by saying that property was not yet transferred into your name. And so
one property is not. The rest of my sisters, they transferred their property.
Well, they could still come back against your sisters who transferred property out of the name of the estate, because these are estate debts that must be paid by everyone.
Okay, that's good. So I'm not the only one held responsible. They're also held accountable also.
Absolutely. Okay. All right. Have a great Sunday, Patrice.
Right.
Thanks for giving us a call. Bye-bye.
Thanks. Bye.
215-227-2727. Let's see. Should we take a break? Okay. We're going to take a break, folks. We've got people on the line. Stay tuned. We'll be right back in 2 minutes.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's More Court Radio with your host, Dean Weitzman.
Good morning and welcome back. I'm Dean Weitzman, and it's still Sunday, September 18th, 2016. You know what's going on today, folks? The Philly Rock and Roll Half Marathon. Center City's crazy. There's so many people down there. I think they're having about 16,000 runners. And they're going from Center City up the Kelly Drive, across the Falls Bridge, and back down MLK Drive. The whole thing takes about 12 and a half miles, and is going to raise money for a form of epilepsy called Dravet syndrome. And so, 16,000 runners and all their adoring family and fans. There's a ton of people in Center City. Streets are closed. Be careful getting down and around and give yourself some extra time. 215-227-2727 opens the door to all your legal problems. Solution to all your legal problems. We don't create legal problems at My Philly Lawyer. We solve them. 215-227-2727. Let's talk to Jay from Winfield. Hello.
Hello.
Hi, Jay. How are you?
I'm good. Good morning. I listen to you guys all the time, so I have a question for you.
Shoot.
Okay. Recently, my daughter passed, and very recently, as August 25th. She was not married. She has two children, a 20-year-old daughter and a daughter that's not quite 3. She'll be 3 in December. Someone said to me that I am the youngest grandchild's legal guardian because my daughter was not married. I'm trying to figure out if that is actually true or not because she does have a living father.
Okay. And the living father would take priority over a grandparent. That's not to say that you guys can't decide to split custody or raise the child together or any of that, but clearly if the father wanted to have sole custody of his daughter and he is the father listed on the birth certificate, there's no question about his paternity, then he has the right to do that.
Guardianship is a judicial determination. People don't wake up in the morning and say, I'm the guardian. You have to file a petition with the court.
Okay, so there's no fight about it. It's as far as I can tell, the father is not being actively involved in the child's life, and the child is not physically living in my home at this point. So trying to go forward with making sure that she is okay and taken care of.
I'm sorry, Jay, did you say the child is or is not living in your home? Is not.
Is not living in my home, but she is not living in her father's home either.
So whose home is she living in?
The friends of my daughter.
Okay. Well, somebody, whether it's the friends of your daughter, you, or not the father doesn't have to do this, but clearly the friends or you do, and that is to file a petition with the court to acquire or become the guardian, the legal guardian of your granddaughter. Because when it comes time to putting her in school, the school district is going to need to see legal paperwork making you the guardian.
Okay.
Because the legal guardian has the legal right to make decisions for a minor. And and that right is bestowed by virtue of your relationship if you're the parent. But everybody else needs to have a petition filed and become the guardian.
Okay, so the person who is caring for her right now also has children by the same person, the same father.
Okay, so they're half brother and half sister.
Right. So she's basically staying with her siblings, and that person is really wanting to be her guardian.
Well, that person needs to file a petition with the court.
Gotcha. Okay. That was my question. Excuse me. That was my question. I was a little concerned about what my actual legal obligations were, not my moral obligations, but my legal obligations.
Right. You have no legal at this point. You have no legal obligations, and any obligations you feel that you have are from your heart.
Mm-hmm. Okay.
Thanks, Jay. Right. Take care.
Thank you very much.
You're welcome. Bye-bye. Another satisfied court radio listener. That's what we try to do, because folks don't have the time and or the money and or the whatever relationship to walk into an attorney's office and get these kind of questions answered.
And they have legitimate questions.
Yeah, absolutely. All right, let's talk to Makita from Trenton, New Jersey. Hi, Makita.
Good morning.
Good morning to you. How's things in Trenton? You know, whenever I think about Trenton now, I think about that woman who walked into some 7-Eleven and bought a ticket that was like $400 million. I mean, she's like a half a billionaire now, and she bought it in Trenton. Do you remember that story?
Yes. Yes.
Was that you?
I know that story. I remember her from going to the gym, but not from Trenton. I would see her at the LA Fitness in Oxford Valley Mall.
Uh-huh. Yep.
Yeah.
Could you believe?
Nice lady.
What nice lady? Good. That's good. What?
Yeah.
I wished it was you. That's all. I thought, maybe you're. No. Okay. Well, maybe the next $400 million lottery will be yours.
I'll keep playing.
All right. Well, don't forget that it was my good wishes that helped you along there, Makita.
I won't.
All right. So tell me, what question do you have for Saul or I about estates?
A family member has a will, and the executor of the will is a niece, and the niece's name is spelled incorrectly on the will. Is that going to be a problem?
Go ahead, Saul.
No, that would not be a problem unless there's confusion among family members with similar names.
Okay.
It's interesting. As a rule, when somebody drafts a will document, they're usually not publicizing that to other family members or letting other family members know who are not named as executors. As a rule, we don't encourage people to do that because a will document is not written in stone, which means that you can change that document anytime your heart desires. And if you choose to make a change, you want to change a name, you want to add a beneficiary, you want to substitute an executor, if you have already published that information to other family members, now you're kind of in the hot seat because now you got to provide an explanation for why you change your mind. And if you don't publish that information, which we encourage people not to do, then you can change your mind anytime you want because statistically, people who are sophisticated enough to do simple wills, they'll change something in that will 2 or 3 times over the course of a lifetime, and usually it's a life-changing event, and most of these events are very positive. So, for example, if you're single and you get married, you want to add a spouse's name to a will, or if you're married and you have the good fortune of having children, you're going to change your will to include the names of the children. That might hold true for becoming a grandparent or for many, many other legitimate reasons. But those will changes are personal to the maker of the will document, and the maker of the will document shouldn't be in a position where they have to go and explain to somebody why they took them out of the will.
Makita, does that help you? Makita, help you?
It does. It does. You clearly said that as long as the person's name isn't similar to anybody else's, it should not be a problem, or it won't be a problem.
It won't be. No. I mean, if you had, Joseph and Joseph Jr., I could see where confusion could occur, but no, if there's just a typographical error on a name and nobody's confusing them with anybody else, you're good to go.
Thank you so much. You've been really helpful.
Makita, keep listening to Court Radio, and thanks for being a loyal listener.
Always.
Hey, listen, stay on the line, dear. I'm going to have Monica get your address, and we're going to get you a Court Radio T-shirt. All right. She's hopefully patiently waiting on line 3. And now let's move along to line 4. Julius. Julius.
Yes.
Good morning to you. How are you?
Good morning to you. I'm pretty good.
Northern Liberties is where you hail from.
Yes.
They have some decent pizza over in Northern Liberties.
Decent restaurants.
Yeah.
Yeah, plenty of them now.
Yeah. Were you there before Northern Liberties was hot, or are you just like a recent glommer
I was
on?
here well before it was hot.
Oh, yeah. Yeah. I sued a company up there, Schmidt's Brewery, when they were in in Northern Liberties. You remember that, Saul?
Oh, how can I forget?
Saul and I we had to go see the bottling plant there. But that's long gone. That's long gone, and all the rich yuppies are now living in Northern Liberties with you, Julius. So,
yes.
All right. Listen,
I'm trying to get some of their money.
Things could be worse, you know? I mean,
sell your property and cash in.
Yeah.
All right, Julius, what's your question?
All right. My grandparents passed away years ago, and the house is in my grandfather's name and my grandmother's name. My mother, took over the house, and then she passed away. And it went to her sister, which became the administrator of the home. And both of them, my mother and my aunt were mentally ill. And my aunt is somewhere in Norristown, I guess, mentally ill. And I've taken over the house, and I've been in here for like 10 years. And when I came in, she had not paid any of the property taxes, and I paid it all off to stop the foreclosure on the home. And within the last 5 years, because the area being so hot, like you said, my property taxes are back up to like $17,000, and I don't want to pay it anymore. I want to just sell the home. And I was told I would have a problem by her being mentally ill, becoming the administrator of the home, so I could sell it.
Okay, wait. Let's go back a second. All right, let's talk about when Mom passed away, did she have a will?
No, she did not.
Okay, so when Mom passed away, I got to go back one more step. When your grandparents passed away, there was two siblings, your mother and her sister. Any others?
Correct.
Any others?
No.
Okay. I'm going to assume your grandparents didn't have a will. So when the last of them died, who was that, Grandmom or Grandpop? Who was the last to die? Grandmom. So Grandmom dies. She's the owner of this property. And when she dies, it becomes the property of her two daughters, your aunt
Correct.
and your mom.
Correct.
Okay. So now your mom passes away. Her one half of her property passes to her heirs. That's you. Anybody else? You have any siblings?
Yeah, my two younger brothers.
Okay. So Julius and his two younger brothers, like a movie, Julius and his two younger brothers own one half of a property, and the crazy aunt owns the other half.
Yes.
Wow. Does the crazy aunt have children?
No.
Okay. So I guess you become the owner of that property, you and your two younger brothers, when the crazy aunt passes.
Okay.
Because she doesn't have any other children.
Anytime soon.
Yeah, because she's well cared for in the mental institution, so she'll be fine for a long time. But you only own half that property, so you've been paying property taxes and keeping the property up, and you've got a 1/2 interest. Now, how do you get rid of it? It becomes difficult. Can you force a sale of a property, or can you, this, because she's the 1/2 owner. You'd be better off going up there maybe and getting the crazy aunt. She hasn't been declared incompetent, has she? By a court.
Not that I know of.
Okay. Well, you might want to see if you can go up and visit her and get her to sign off on a deed giving you the right to the property.
We've had similar situations where elderly family members expressed no interest in owning a particular property, and they were willing to sign off on a deed transferring their interest to other family members.
So we could prepare a deed for you, okay, cleaning this property up and transferring it from your crazy aunt to you and your brothers. And then you could take that deed to your aunt, and if she would sign it and it would be notarized at the wherever she is, then it would become.
I don't think she would be able to, because she's like she's bipolar, and I don't think they're going to allow that.
Well, it really depends, what day you get up there. She might be completely sane and normal, and if she's taking her medications, she could be fine. But again, the only way you're going to get that property in your name and the name of your brothers is to do that. Otherwise, you have to wait for her to pass, and then you become the owner of the property. Sorry for the bad news on a Sunday morning. You know, what can I tell you? But it's the way things are sometimes.
Wow. All right.
Julius, come on, smile. It's not so bad. You're still living in the property, you know. Nothing's changed,
Right.
and probably nothing's going to change.
Well, a lot has changed. Like my property taxes were $1,200 a month, a year, to now $3,500 a year. It's a big change.
Yeah, that's a hurt piece. Yep. All right, well, good luck trying to figure that out. But again, you're really in a bind because you're the owner of only half a property, and the other half is owned by somebody who you're telling me may not be able to transfer that property. I haven't given up on that idea, so that's where I would focus your attention. I'd go visit Aunt. That's what I would start, just by visiting her and explaining that she's the owner of a half a property, but she owes half of the property taxes. So technically, she owes. If you say there's a $17,000 tax bill, she owes $8,500,
including the 15 I paid before this.
There you go. So, I mean, that might be considered a gift. If you paid it, you paid it. But but at least she owes $8,500. Plus, she owes half the upkeep and half of everything else. You could go sue her for, the city of Philadelphia, and just sue her for the $8,500 in taxes she hasn't paid you, and then maybe get the property some other way through litigation, I guess. But again,
that sounds good.
Yeah, but I'm telling you, my advice is, the easier way to do this is to go make friends with your aunt and see how she's doing and see if she's competent. Because, again, if she's taking her meds, she might be competent. She might realize, hey, I owe this money, and she might be willing to sign off just to get rid of the debt. Give it a thought.
Sounds good to me.
All right, Julius, thanks for calling Court Radio, brother, and have a great Sunday.
All right, you too.
All right. 215-227-2727. Folks, we got to pay the bills at Court Radio, and we need to honor our sponsors. So give us 2 minutes, and we'll be right back.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's more Court Radio with your host, Dean Weitzman.
Good morning and welcome back, Court Radio listeners. It's Dean Weitzman, and it's still Sunday, the 18th of September, 2016. Oops, 2016. I almost had one of those. I was transferred back to 1979, graduating high school.
Is that a senior moment?
Yeah. When did you graduate high school, Eric? 87. That's when I graduated law school. Yep. But he's got more gray than I do, folks. But he's all natural. 215-227-2727. Let's talk to Darius from Chester. Good morning, Darius, and welcome to Core Radio.
How you doing?
I'm well, thanks. You from Chester, huh?
Yes.
Chester proud. How's things going down there?
Well, it's tough, but, we're surviving.
I hear that same story all the time out of Chester. I'm waiting for things to change down there, so it's, a pleasant place to live and raise some kids.
One day.
Yeah, maybe. All right, so tell me something, Darius. What brings you to Court Radio this morning?
Well, my question is, I had a grandmother that's just passed away,
mm-hmm.
and she had 4 children,
mm-hmm.
and my father passed away before she passed away,
mm-hmm.
and basically she had over $500,000 in assets and properties that I know of,
mm-hmm.
and I was privy to some of the information because I had to sign papers at the table with her financial advisor. And what I need to know is, because she passed away, all of a sudden her 3 children all of a sudden became the beneficiaries of her estate, and leaving out my father. Since he passed away, I was told since he passed away that his children wasn't entitled to anything.
That's a good question. Okay, so it takes me back to my law school days where properties were dispersed per persterpes. Oh my goodness, I can't even remember the Latin term. But if you have 4 children and one of those children died, does that 1/4 of your estate pass to your grandchildren from that child, or does it get divided equally? And the question, I guess you didn't answer one question, and that is, did she have a will?
She had a will prior to him passing away when he was actually they were children.
Right.
Leaving her estate to her children.
Okay. So
prior to him passing away, I'm talking about maybe 30 years prior.
Okay. The document is still legit. And the question then becomes, how is the document written? Because it could be written either way. It could be written that the property from your one child passes to that children's children, okay? Or it could be written that the properties passes just to your 3 surviving children and not to the grandchildren. I would need, and Saul would need, to see that will in order to advise you.
I can give you a general answer to that question. The general answer is that if a parent leaves property to children, the intention of the parent is, God forbid, a child passes away and that child is survived by children of the deceased child, grandchildren.
Well, maybe I didn't explain this further. I was actually halfway an adult before that will was made up.
It makes no difference. Your age is not controlling. There is in Pennsylvania, there is an anti-lapse statute. And in plain English, what that statute does is it makes sure that if you name a child in a will document and that child has predeceased, but that child is survived by children of their own, the surviving children will inherit the portion going to the dead parent, so that if your grandmother left a will and she left the 4 children, even if your dad passed away, his interest under the anti-lapse statute would pass equally to his surviving children.
So that's good news, but I would suggest to you that you need to retain counsel in order to perhaps clear the way for your claim to be made.
And the other thing, I was signing all types of papers myself directly for her financial advisors.
You have copies?
And with my name on it, but I wasn't given any copies. And they claim they can't find any of their paperwork.
Yeah, well, unfortunately, the lesson learned there for our other listeners is that if you sign your name to something, you insist upon getting a copy before you leave, or you don't sign. That's it. It's as simple as that. And so, unfortunately, I don't know what you signed away, what you didn't sign away. Who knows? You did it without the advice of counsel. I can't answer that question, but I can. But according to Saul, you stand a good chance under the law, generally, of being a beneficiary of your grandmother's estate, even though your dad predeceased her.
I need a lawyer.
You need a lawyer.
Yes,
Absolutely. All right, so you give us a call during the week. That's the way it works. You know, on Sunday mornings, we're free. After that,
using the same number?
Yeah, it's the same number. After Sunday mornings, though, there's going to be consultation fees, and you'll have to get together. We'll have to see documents, but you give us the names of the people that you know are involved, and we can start touching base with them and getting some answers for you.
The one other thing I should mention to you that they seem to be living high on a hog. Them and their children, but my father has passed away, and his children are walking around with their hands in their pocket with nothing.
Yeah,
that hurts me bad.
It would hurt me too. And if there's a way for you to get a piece of that pie, I think you deserve it. So again, you need to sit down with an attorney, and that attorney needs to then reach out to the attorney representing the estate and try to get some answers for you.
Thank you very much. I appreciate that, sir.
Have a great Sunday, and thanks for calling Court Radio.
All right. Bye-bye.
Bye-bye. Yeah, unfortunately, folks, we're just about out of time. Just enough time for me to thank Saul for schlepping up from the shore, and putting his clothes on and getting out of the bathing suit and stuff like that.
Anytime.
Yeah. Saul, Everybody loves when you're on Court Radio. So we hope to see you again real soon now that your summer hiatus is over.
I look forward to it.
All right. Folks, he'll be back again. You can count on it. If you've got estate questions, questions regarding the creation of a will, Saul's available all week long, every week. All you got to do is call the office, tell him you heard him on Court Radio, and he'll get on the phone with you and make life better. 215-227-2727. You call that number during the week, and Saul will be there for you. No questions asked.